Levante Washington. Thank you. You're requesting an adjournment.
We are requesting an adjournment.
How much more time did you need?
I did not hear you, Judge.
How much more time did you need?
I think 2 weeks will be just fine, Judge.
Right out of the gate, this sounds routine. A probable cause conference, a request for adjournment, bond continuing. But don't let the calm courtroom tone fool you. What's unfolding here is a ticking time bomb. We've got Lante Washington already on bond, already under supervision, and already flagged for 2 back-to-back positive cocaine tests. That's not a minor technical violation. That's a direct challenge to the court's trust. Judge Simpson, methodical but sharp, isn't just processing paperwork. He's testing credibility. The defense wants a 2-week adjournment. The judge trims it to 1 week. That subtle shift tells you something. This court is watching closely. When someone on bond tests positive twice, especially in a tight time frame like December 27th and December 30th, it triggers a serious legal consequence, potential bond revocation. And once bond is revoked, you're back in custody. No more walking out those doors. Now here's the tension. Washington denies using. The samples are being sent for lab confirmation. The defense is asking the court to hold it in abeyance. Basically pause judgment until lab results confirm the quick tests. On paper, that sounds reasonable. But in practice, judges deal with denials every single day. The real question isn't just did he use, it's can the court trust him? And in a courtroom, credibility is currency. Once that's gone, everything changes. Stay with this. Because what happens next is not just about drugs. It's about honesty, accountability, and a judge who can smell when something isn't adding up.
Without objection, probable cause conference, January 23rd, 2025, 9 a.m. Bond continues.
That's the bond, Judge.
Oh, boy.
Yes.
Go ahead.
Your Honor, Mr. Washington was remanded at his last hearing because there was a positive test. Please state your name for the record, sir.
Levante Washington. Thank you, sir.
Thank you, Your Honor. As to the probable cause conference, we are respectfully requesting a very brief adjournment. And we do understand that Mr. Washington was asked to be in person today because of the progress report that was sent out. And we are also willing to address that one, whoever the court would like.
Why don't you go ahead and address that?
So as the court is aware, Community Corrections did send out a progress report. Mr. Washington did test positive on both 1227 and 1230 for cocaine. He did already send out the 1227 sample to the lab for confirmation. We have not yet received the results from the lab one way or another. He does plan on, after court today, appearing in Community Corrections to have his most recent test sent out for confirmation from the lab. He had planned on doing that today in any event. However, as to the progress report, we're asking the court to hold it in abeyance until we get those lab confirmations back, whether or not that was a positive test. Mr. Washington does deny any use. He is here today with his mother, who I have also had the opportunity to speak with. He resides with his mother, and his mother also says she doesn't know him using. Of course, she's not with him all the time. However, Mr. Washington does deny use. That's why he sent it out to the lab. So we're just asking the court to hold this in abeyance until we get that confirmation one way or another.
And then if it comes back positive, what do you think I should do?
I would ask that be addressed at that time.
This is the moment where Judge Simpson pivots from procedural to personal when he asks, "What do you think I should do?" That's not sarcasm. That's a credibility test. Judges often do this to force a defendant to confront the logical consequence of their argument. Legally speaking, if the lab confirms those positives, bond revocation becomes almost inevitable. Bond conditions typically include no drug use. A confirmed violation isn't just a slap on the wrist. It signals non-compliance with court-ordered supervision. And courts take that extremely seriously. But notice Washington's strategy. He insists nothing will show up immediately if tested today. That's bold, because if the judge sends him for an instant test and it comes back positive, that's immediate incarceration and complete loss of credibility. Okay, here's the key legal insight. Preliminary screens can sometimes produce false positives, but 2 consecutive positives. That weakens the defense's position significantly. The court isn't just evaluating chemical results, it's evaluating behavior patterns. Let me ask you this. If you were in Judge Simpson's position and had 2 back-to-back positives, would you wait for the lab confirmation, or would you act right then to protect the integrity of the court's order? Because in this courtroom, patience is limited, and trust is already thinning.
So you just don't want me to lock him up today?
Certainly not today, Your Honor. Mr. Washington appeared knowing that that was quite frankly a possibility. He's staying on top of this, continued to test even after he did get that positive result, went to community corrections and paid the $30 to have that sent out.
You going to have a test today?
Yes, he's appearing. He is going to go to community corrections after court today to have his test from the 30th sent out, and I believe also to be tested again.
Why do I have the feeling I'm not being told the truth? I've got 2 tests back to back with cocaine. So let me ask this question. If I send you over today and I get those results immediately, is anything going to show up in your system?
No, Your Honor.
Pardon?
No, Your Honor. Like I say, I got a lot of stuff going on for myself. This is not the only. This is probably the least case that I'm worried about. I'm on GPS tether. I don't have no reason to run or no reason to not show up and come back to court.
That's all fine. I'm more worried about your use at this point.
Oh no, I don't use at all. I'm not trying to pit everything out on the line. But if we can speak privately, then I'll be able to tell you exactly what's going on, but I don't want to pit everybody on Front Street. That's it, in the courtroom.
So, did you read over that progress report?
Me?
Yeah, because I'm getting a lot of people that are amoebas.
Yes, I did read over the progress report.
They're absorbing cocaine. And I'm not sure how that happens. Young lady appears at community corrections, said, I smoked it around him. That must be how he's testing positive. You believe that? Hold on. No. You believe that?
Now we hit the turning point. The secondhand smoke defense. Someone allegedly smoked cocaine around him, and that's why he tested positive. Let's break this down. Scientifically and legally, passive exposure arguments almost never hold up in court, especially with cocaine. It's not like being in a room with cigarette smoke. The metabolite levels required to trigger a positive drug screen are not typically explained by casual environmental exposure. And Judge Simpson knows that. When he says, you might want to just be quiet, that's not anger, that's a warning. He's signaling that continuing down this path could make things worse. Judges dislike being misled more than they dislike the underlying violation. Lying to the court compounds the problem. Notice the tone shift. The judge says, oh, you're not playing it here with me. That's courtroom authority being asserted. He's not debating chemistry. He's evaluating honesty. Here's the emotional layer. Washington doubles down. He says it's the truth. That's risky, because if that lab confirmation comes back positive, the judge will remember this exact exchange. Audience question, do you think he truly believed that explanation would work, or was he panicking and grabbing at anything that might buy him time? Because from where we're sitting, Judge Simpson isn't buying it, and you can feel the temperature in that room rising.
Yes, Your Honor.
Really?
That's the truth.
Counsel Pro, you might want to just be quiet, because the thing I don't like a lot are people that aren't telling me the truth. Because you can go play your game anyplace else. You're not playing it here with me. Counsel approach. Anything else you want to say?
No.
I'll give him one shot. You want to tell me? I mean, from what I understand, he comes over from another place. He's in our jail, gets out, and is saying he wasn't using. I got 2 tests.
I understand that, Your Honor. I would just reiterate my request to hold this in abeyance until the lab confirmation comes back one way or another, and to address that at that time. If, in fact, the lab confirms that it was a positive result, I would ask for that, Your Honor, and I have nothing further to add. But except that, Mr. Washington, I do truly believe will be in attendance to its next future court
I'm
date.
not so much worried about his attendance. I'm worried about his using and then lying to me. That's what I'm worried about. And then getting other people wrapped up lying. You're not an amoeba. It's not going to be in your system for 6 days, at least, in this way. Anything else?
Nothing further from me, Your Honor.
I'll grant the adjournment, and maybe, I would have normally, under most circumstances, put it out 2 weeks, but I'll put it out 1 week to the 9th, 2025, 9 a.m. At this point, however, the defendant's bond is revoked. Defendant's remanded.
And there it is. Bond revoked. Remanded into custody. That decision speaks volumes. Legally, bond revocation means the court believes there's either a violation of conditions or a significant credibility issue that justifies detention. The judge didn't wait for lab confirmation. He acted based on the pattern and his assessment of truthfulness. This is about more than drugs. It's about trust. When a defendant on supervision is perceived as dishonest, the court's tolerance evaporates quickly. Judges have discretion in bond decisions, and here, Judge Simpson exercised it decisively. Notice something important. He shortened the adjournment to 1 week. That tells us he's not closing the door completely. He's saying, we're going to revisit this, but from custody. Strategically, that puts pressure on Washington. It changes the leverage dynamic entirely. Being in jail while waiting for lab results feels very different than waiting at home. Would this have played out differently if he had admitted use immediately? That's the question hanging over everything, because now the stakes just escalated.
Thank you, Your Honor.
He's asked that we address bond again today. I have made a number of contacts. I've reached out to his community corrections agent. She indicated to me that in order for him to get into CCOP while in custody, the court would need to send over an order to their attention so that they could at least start the process. However, he wouldn't be able to do the assessment until he's out of custody. So I guess our first request today would be that the court consider an order allowing him to enter the CCOP program so that he could be assessed. I also reached out to Matt Statman to see if he could come to the jail and do an assessment. I know that the court would like to see some type of plan in place to address his sobriety. He didn't want to address the court again today. He indicated that he wanted to take responsibility and be open and honest to the court and explain to the court exactly.
So what changed? Why does he now want to be open and honest?
This is powerful. Judge Simpson doesn't just accept the apology, he interrogates the timing of it. What changed? That question cuts to the core of accountability. Courts hear apologies constantly. What judges look for is sincerity backed by behavior. The defense frames it as shame. That's significant. Shame can be a powerful motivator, but it can also be a shield. The real shift appears to be this. He's now in custody. And custody changes perspective fast. Here's the legal strategy emerging. They're pivoting toward treatment. CCOP, a corrections program focused on rehabilitation. That's smart. Courts are often willing to consider structured treatment plans, especially in addiction-driven cases. But they need a plan, not promises, a plan. Audience engagement. Do you think the apology is genuine growth? Or is it the realization that jail is uncomfortable? Because judges can detect performative remorse quickly. The next few minutes will determine whether this becomes a redemption arc or a missed opportunity.
I think primarily, Your Honor, he indicates that he was extremely shameful of what had happened. I think he could better say it in his own words. His family is here. He knows that he's let them down significantly over the past few years. I think this started back in 2023, right?
Yes, ma'am.
Yeah. So he knows that he's let them down, and he just has not been very open with himself about the extent of his addiction. He and I had a great conversation. He has a lot of insight, and he told me himself that he is not great with words, but he's going to do his absolute best to try and express himself to his honor so that he could see and understand where he is in regards to.
His mom and dad here.
They are. His mom is that your dad?
Mom,
Yes, ma'am.
That's both of them.
No, this is my mom.
His mother is here, Your Honor.
What do you want to tell me?
First of all, I want to apologize for being dishonest with you. Like I say, whatever we can do to move forward and help me with the problem that I have, I just want to do the right thing, Your Honor. I'm not even gonna lie to you. Like I said, I'm not the best with words. So
I'm understanding everything you're saying.
I know. I just asked for another chance. Honestly, I do.
Well, not funny, but why were you lying to me? I mean,
I was just in disbelief.
did I look like that stupid?
No.
Huh?
No, I was lying to myself, honestly.
Good point. But you had lied to your mother about that, right?
Correct.
Right?
Yes, sir.
Because see, most people don't think I remember anything, but Mama was sitting on that side. All of a sudden, you may not have seen this, but all of a sudden, her baby was about to be in trouble, and Mom came all the way from that side over here because Mom was going to jump up and say anything she could to try to defend her child. Mom, am I right? And then the biggest disappointment was on her face because she couldn't defend you. So more than what you did to me, more than what you did to yourself, you did that to your mom. And I'm going to tell you, the way I am, that sometimes is a harder thing for me to forgive when you do that to your mom. Because I when I saw her coming over, I said, "Oh, what's she gonna do?" But because she was gonna battle for you. And that's who you really let down. You got me?
Yes, sir.
This is no longer just a legal proceeding. This is human. Judge Simpson shifts the focus from himself to the mother, and that's strategic. He's reframing the harm, not as disrespect to the court, but as heartbreak at home. From a judicial standpoint, this is impactful sentencing psychology. Judges often appeal to personal responsibility by highlighting family impact. When he describes watching the mother move across the courtroom, ready to defend her son, you can feel the weight of that moment. Notice Washington's response. Yes, sir. Short, controlled, no argument. That's acknowledgement. Here's something critical. The judge says it's sometimes harder for him to forgive when someone hurts their parent. That tells you how much moral credibility matters in his courtroom. Think about this. Addiction cases often revolve around broken trust, not just with the court, but with family. Do you think that moment when the judge described his mother's disappointment hit harder than the bond revocation? Because sometimes the legal consequence isn't what breaks you. It's seeing the impact on someone who still believes in you.
So, Ms. Acker, what kind of plan?
So, Your Honor,
I understand the CC. I get that part of it, but what kind of plan is in place for him so that I don't let him out of here, and then next thing I know, I'm having to put him back in because he can't.
And Your Honor, I think that I spoke with Mom today, and I know he was on tether initially, and I think Mom, again, not realizing the extent of the issue, understood that he could not go, but people came to the house. And that's where his next level of exposure happened. And I told him, I said, the tether can keep you from going places and have them monitor you, but it obviously didn't stop you from testing positive. And he explained to me that it was due to influences that he had allowed back into his circle and his bubble. So what Mom has assured me of is that now that she knows that his access is not just based on him going out, she with it being her house, is also going to limit or prevent anyone from coming in to see him, especially while he's in this very vulnerable state and until we can get him secured into some type of treatment. That was the commitment that Mom made to me today. I will say something too, Your Honor. When I had spoken with him, this is part of what I was expecting him to say to the court. I asked him, I said, so why did you lie? And he said, because my mom was there and I didn't want to tell her the truth. I wasn't here at that last hearing, so it is quite funny that the court is able to see exactly what the root of that particular situation was.
I could see it on Mom's face. I just didn't know who it was going to come at. I didn't know if it was going to be at me or what it was going to be at, but I could also see the hurt on her face. And young man, you got to do better.
Promise to. I promise I won't drop dirty again.
All right, here's what I'm going to do. At this juncture, secondly, I'm going to, well, is there anything from the people?
We'll leave it in your discretion, Your Honor.
All right, here's what I'm going to do at this point. Secondly, I'm going to deny the request right at this moment. I want in writing what is basically the plan.
Okay.
That it would be reinstated. He's not going to have folks coming over to his mother's house. Because, young man, how old are you?
24.
Yeah, she does not have to give you a home.
Mm-hmm.
This is structured accountability. Judge Simpson doesn't slam the door, but he doesn't open it either. He demands a written plan, not verbal promises, not emotional apologies, a documented commitment. That's smart judicial management. By requiring specifics, no friends coming over, treatment enrollment, CCOP order, he's creating measurable conditions. If Washington fails again, it won't be ambiguous. It will be documented noncompliance. This is how courts protect themselves from manipulation. Everything spelled out, everything in writing. And here's the subtle power move. He makes Washington's own commitment the basis for release. If he messes up, it's his word on the line, not his mother's. Audience question. Do written plans actually prevent relapse, or do they just create clearer consequences when someone slips? Because what we're witnessing is a judge trying to balance public safety, personal responsibility, and the possibility of rehabilitation, all in real time.
You got that?
Yes, sir.
So I want that laid out, that this is what the defendant is willing to do. I understand what Mom's going to do in terms of protecting her house, but I want what his commitment is in writing. So if he messes it up, it's his word. It's not something Mama didn't do. All right. And then I will consider, I'll look at that and based upon what we talked about, to try to get him released. I want also in there the CCOP portion of, of that in the order, and then I'll look at and do that. Okay.
Okay, so we'll look at the order after we get you the plan.
You get us a plan, and then you just prepare an order for
Absolutely.
release, but I want everything laid out, spelled out as to what he's going to do.
Understood, Your Honor. I'll work on that today.
You're not an amoeba. I'll have him look it up when he gets out as to why I'm saying it. He knows why I'm saying that.
Thank you.
I was just in the room, and that's how now go. Young man, you break that woman's heart.
This closing exchange says everything. Judge Simpson ends not with legal jargon, but with a warning rooted in humanity. You break that woman's heart. There's a place in the jail, and you will just stay in there. That's conditional mercy. Here's the professional overview. The court revoked bond after 2 consecutive positive cocaine tests and concerns about dishonesty. However, the judge left a pathway open. A structured written treatment plan, including CCOP participation. Release is possible, but only if backed by concrete commitments and verifiable steps. This case highlights 3 critical legal themes. Bond is a privilege, not a right. Credibility in court is everything. Treatment opportunities exist, but only when accountability is real. Judge Simpson made it clear, the issue wasn't just drug use, it was lying about it. Whether Washington turns this into a comeback story depends entirely on what he does next. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.